Okay, well, hello everybody. Alex, co-founder of Sprintlaw here, and welcome to the February 2026 edition of our monthly webinars. This month, we're going to be talking about capital raising. The presentation's entitled Before You Raise Legal Essentials for Startup Capital Raising. Before we get into the legal content, just a quick introduction to Sprintlaw for those who don't already know us or who are not already clients. We're an online law firm really made to make legals accessible for startups and smaller businesses. Unlike traditional lawyers who charge by the hour, everything we do is fixed fee. We have services in all the different areas of law that a business might need help with, from getting your company set up, drafting contracts, employment contracts, data and privacy, consumer law, IP protection, and as we'll be talking about today, capital raising and financing legal docs. We have an optional membership. About 90% of our clients are signed up to it, and it also gives you access to sort of ongoing support. If you're looking for us to be sort of lawyers for your business, you also get access to our software platform, which has tons of features. We're always releasing new ones every week as well. So there's a lot of stuff coming soon, but at the moment it has a full e-signatures tool, unlimited quick calls with our lawyers, free document templates, credits to use on legal services throughout the year, and our legal AI tool, Taylor AI, where you can ask sort of simple legal questions and get some answers under Australian law. Um, a bit more about us. We've been around for nearly 10 years now. Started in 2017. We have a little over 8,000 clients. We've expanded over to the UK and New Zealand, so we can provide help there for any businesses that need that. And we are a happy group of people, as you can see from the picture, who love helping smaller businesses. We've also, as we'll be talking a little bit about today, been through the startup capital raising journey ourselves. We've raised about 5 rounds of capital and have grown the business over the last sort of 10 years. So we know what it's like to sort of be in your shoes thinking about raising capital. And if you are in need of some advice following this webinar, do feel free to book in a free consult with our team. And we have some discounts at the moment as well for capital raising related legal services if there's documents that you might need drafted and so on. So today we're going to be really doing sort of a 101 on capital raising and the legal things that you might want to be thinking about if you are preparing for a raise. We'll be covering briefly sort of the background to getting ready for a raise in terms of getting your companies set up correctly and other legal documents and sort of hygiene factors that you might want to have in place before you dive into raising funding. We'll then talk about the different ways that you can raise funding for your company, covering equity, debt, and then convertibles, safe notes, and other funds, sort of forms of raising. We'll dive in a little more detail into equity raises. So if you were going to do an equity raise, sell off a part of your company to investors, what are the documents that formalize that? What goes in them? And what do they sort of look like? We'll also look at safes and convertible notes, which are becoming one of the most popular ways, particularly for early stage startup companies to raise funding, and what goes in those documents. We'll briefly touch on some legal requirements around what you can and can't say when you're raising capital and who you can and can't speak to. And then we'll also briefly touch on some of those other funding types and what the documents that may be involved in raising funding that way. As I'm going through, we've got a Q&A feature in Zoom. Do feel free to drop questions. We may have some time at the end for questions, but I don't mind answering them as I'm going through the slides. If something pops up that's relevant to what we're talking about, it could often be useful to answer questions about it. So do use that feature, and I'll keep an eye on it as I go through. So if you find yourself in the position of thinking about raising funding for your business, one of the first things you want to do is make sure that your business is presentable and your sort of key legal hygiene factors are taken care of before you go out and start talking to investors or anyone about raising funding for your business. So I won't spend heaps of time on all the different areas of law that you might want to cover, but in general, it can be a good time to take a look at your business, look at your general legal health. Have you got your intellectual property secured? Do you own your brand name? Have you got proper contracts with your customers? Have you got proper contracts with your employees? Do you have important referral partnerships that have been documented? Do you have suppliers that are really important to your business, and have you locked those things in a contract? So, whilst not specifically about the fundraising process, normally if you're going out to investors of any kind and asking for them to invest in your business, they're going to want to do some due diligence or ask questions about your business to make sure that there's no skeletons in the closet. And so, as long as you have made sure that you've got some of your sort of key legal items in these areas taken care of, you can confidently say, yes, we've taken care of most of our risks. And one of the things we often do when people are thinking about fundraising is we'll basically do like a legal health session with them in advance and ask them some of the questions that I just alluded to. Okay, how are you set up? How have you registered your brand name? Do you actually own it? Have you checked that no one else owns this brand name? And so on. When was the last time you had your contracts reviewed? Did you use online templates, or are they properly drafted, et cetera, et cetera? So again, I won't spend too much time on this, but do have that in the back of your mind, as it can often be a really good time to sort of clean up your legal hygiene in preparation for a capital raise. And one of the most important pieces of that, which I will spend a bit of time on, is your business structure. So if you're thinking of raising funding, having somebody invest in your business, and again, we'll talk in a moment about the different ways that can happen, either through selling a piece of your business, which is called an equity raise, or taking out a loan or something in between, like a safe note or convertible note. In any form, you want to be thinking about what are these people investing in? And usually, there are different ways to run a business in Australia. You can set up as a sole trader, partnership, and so on. But usually, or nearly always, we recommend that businesses that are looking at taking on funding are set up using a company structure. The reason for using a company structure is a company is sort of a separate legal person to you, a founder or an individual owner of your business. And because it's a separate sort of entity, you can sell off pieces of it, and it can be owned by more than one person, which is difficult to do with like a partnership or a sole trader structure. You also benefit from limited liability. So in general, if there are issues in your business, the liability is limited to your business, and you as an individual owner are sometimes or are often protected from risk. Now, if you're raising funding, it may not fully protect you as an individual, but it certainly protects you from risk from your customers and employees to have a company structure better than operating under the sort of other models. And it's just a professional structure that looks good and is a great way to present as organized for a fundraise. Now, having a company is sort of a baseline requirement or strong suggestion if you're raising funding, but there's a few different company structures that you can use, which we have on screen here. We've got the single company structure, the dual company structure, and then on the right we have a trust structure, which is actually one of the most common startup fundraising structures. So I'll just kind of explain the difference. And now all three of them you could use to raise funding, and they each have different pros and cons. A single company structure is just when you have one company, and that company may be owned by the founders and any investors. The company, as I said earlier, is a separate legal person from the founders and the investors, but it's owned by them as shareholders. They'll own a piece of it or hold shares in it. The company will also have directors, which are different to shareholders. They're the people that control the company. So the directors are sort of like the mind of the company, and the shareholders you might view as like kind of the body of the company. The company is controlled by the directors but owned by the shareholders. Now, oftentimes founders are both shareholders and directors. Investors are often only shareholders, but sometimes might ask to have a say in the direction, particularly if they're putting a lot of money in, and we'll come to that in a bit more detail later, and then they may too want to be a director. So the simplest structure is a single company where you just have one company owned by the founders and investors, controlled by the founders and sometimes the investors. And that company goes out and it opens a bank account and it employs people and it signs contracts and it owns all the IP of the business. So that's one way to do it. But in the middle, we have the dual company structure, which we often recommend as a more secure way to set up your organization, particularly if you're taking funds into the organization. Um, whilst I mentioned earlier, one of the advantages of a company is you have limited liability, which means that you, as the owners of the company, are generally not liable to customers or suppliers or employees for issues that may happen inside the business. It doesn't affect you personally. Um, if your business is pretty valuable, you might also want your business to have a bit of protections. If there's an issue with a client and the client decides to sue your company and you've just raised a couple of $1 million into your bank account, you've got some pretty deep pockets and you may not want that 2 million bucks that's in your company to be on the line to any clients or others that decide to make a claim against the business. So oftentimes we recommend having a split between what we call a holding company and an operating company. The holding company is a company that sits sort of at the top of your business's organizational structure. It will own your business's most important IP. It might own your brand name. It might own your domain names and other sorts of things. It may have a bank account and hold a lot of your cash reserves. And then you have your operating company, which is owned by your holding company. And the operating company is the one that goes out, signs contracts with people, employs people, and does all the risky things that you do in business. When you have this structure, what it means is if something goes wrong at the operating company level, there's a mistake that's made, somebody decides to sue your business, they would generally only be able to sue your operating company, and your operating company and its assets would be all that's at risk. Um, but if you've stored your core IP, like your brand and brand name and your brand value in your holding company, and you've stored some of your cash reserves in your holding company, that's insulated from risk. And so it means that, uh, it can be quite difficult for customers or others that may be suing your company to get any access to your core assets. So it sort of acts like a safety deposit box for your key assets. So this structure is quite common for that reason. As the business takes on more cash, starts to have more valuable assets, setting it up in a way where you can sort of use a holding company as a safety deposit box, if you will, can be quite advantageous. Also, once you have two layers, if your business intends to expand into other countries, for example, you might expand to the UK or the US, having this two-layer structure means you can set up more companies and you might end up with a sort of parent-child relationship between your different companies. So for example, Sprintlaw has Sprintlaw Group Pty Ltd, which is our holding company. We have Sprintlaw Australia, Sprintlaw Pty Ltd. We have Sprintlaw UK, and other country entities as well. And what that means is, in our UK business, if something goes wrong in the UK, the liability of our UK business is limited to that UK entity. The Australian company, which is a separate company, a sister company, if you will, of that UK company, has nothing to do with that UK company, and therefore, the risk does not transmit to the Australian business, and vice versa. And neither the UK business or the Australian business exposes our holding company to risk, which is the parent, which holds that IP and cash. So you can see the advantage of creating the two layers. Both immediately you get that risk protection, but also it becomes quite easy to expand on. Now, Diana's asked a very good question. Can you start as a single company and then become a dual company once you're more established? You absolutely can. And that's one of the most common journeys that startup companies go on. And certainly Sprintlaw, when we first started in 2017, we were a single company structure for I'd say about 6 months before we switched to the dual company structure, in part in preparation for our first capital raise, as I'm sort of alluding to here when we were kind of cleaning up our legal hygiene. The longer you wait, though, the more of a administrative headache it becomes, and potentially there can be tax costs to restructuring if your business is well established. So just to explain that, if you're running a single company structure and you want to switch to the dual company structure, you really have two options. You can either make your existing company the holding company and then introduce a new company underneath, or you can introduce the holding company on top and then kind of move all of the owners from being direct owners of this company to sort of sell their shares to the holding company, and then you end up in this model. So there's kind of two ways to do it. Now, the first way probably seems simpler, just add a company at the bottom. But as I said earlier, one of the big advantages of having the holding company is that it's a safety deposit box. It's clean. It just holds IP and cash. It's never had any risks. It's never done direct deals with any of your employees or your clients. If you've been around for a few years and the thing that's going to become your holding company has been doing all kinds of risky things, there might be liability that it's uh, attracted in that period. And so you don't necessarily have a nice, clean, safe company to use as your holding company. So the longer you leave it, the more baggage that your holding company is essentially getting. Uh, and alternatively, if you try and create a new fresh holding company and sell the shares in your company to a new kind of in the middle company, that's the sale of your shares, and there can be a tax cost that you might have to pay when you transfer the shares. If you do it fairly early on, and the company's not worth very much, then both options are usually fine. You haven't done that much that's risky, and there's probably not much value that you would have to pay or tax that you have to pay on the transfer. But if you leave it for years, or you leave it until you're generating real revenue in the business, it becomes a bit risky. Plus, you've got to change all of your bank accounts, all of your software subscriptions, et cetera, et cetera. So it's just a headache. So if you can afford it, we do suggest doing it as early as possible, but you don't have to, as long as you're aware of that, so all those headaches that I just shared. Kenneth asked a question about trust, which I'll come back to in a second when I go into the trust structure. Havisa said, how does the shareholder structure work? How will the money transfer between the holding company and the operating company work? So just to dive into how shareholdings work in general. So I mentioned earlier, when you set up a company, you have shareholders and you have directors. Shareholders are the owners of the company. The directors are the controllers of the company. And usually the founders are both. They don't have to be, but usually they are. And usually investors are just shareholders and only sometimes also directors, or maybe they have a nominated director. So when you set up a company, you will choose how many shares the company will have. You can choose for it to have 100 or 1,000 or 10,000. It doesn't really matter. And then you will issue shares to the owners of the company, which at the beginning, let's say there's two founders, and it's 100 shares you've decided on. You've decided it's going to be a 50-50 ownership. It will be 50 shares each to each of the founders. If you decided to bring on an investor under an equity raise, which again we'll come back to in a moment, you might issue that investor an additional 50 shares. So now the company has 150 shares and everybody owns a third of the company. And that's how the kind of share ownership will work. Now, it doesn't have to be 50-50, 30-30-30. It can be really any percentage that you decide based on the deal that you do, the relative level of control. And usually in accordance with the share ownership, or at the same time, you're signing a document called a shareholders agreement between the owners of the company that explains in great detail how the company is going to be run and what is the significance of being a majority versus minority versus founding shareholder. So it might be the case that, if the company needs to be sold, it needs the approval of 70% of shareholders, or it might say, if the company wants to make these decisions, more than 50% of us need to agree, or it might say, for certain decisions, the founding shareholders must agree. So the details of what the ownership stake means and the control of the business is set out in this document called the shareholders agreement. And then often, the profits of the company are split based on the percentage holdings. So if it's 50-50, the profits of the company may be split 50-50 between the founders. Of course, if the company decides to issue its profits, which it doesn't have to, which is a decision of the directors. That gives you a bit of a sense on how shareholding works. But again, we'll go into that in a little more detail in a moment. And in terms of the money transfer between the holding company and operating company, I should say many people set up the holding company, operating company structure, but don't. I've got on this slide, hold your cash in the holding company because it's like a safety deposit box. We suggest that, although I would say many of our clients that use a dual company structure only put the IP in the holding company because they can't be bothered to have two different bank accounts. It's definitely not preferred from a legal risk perspective, but it can be a headache to have to manage like a holding company bank account and an operating company bank account. So that'll be up to you as to whether you have different bank accounts in the dual company structure. But as I say, it is recommended. In terms of how the cash transfer works, again, that's sort of something that you just manage operationally, and you might decide, okay, we've got $1 million of funding. we're going to be regularly spending. We expect to spend half of that in the next 6 months. So we're going to put half in the operating company and keep the other half in the holding company. Or, and the holding company might have a high interest savings account that earns more interest on the unused cash, and the operating company might have lower interest, but you're going to be spending the money. Or it might be different, and you sort of just use normal bank transfers with the approval of directors, which you would normally need to move the cash around. So it's kind of works how you would expect it to work, and usually handled through funds transfers. And the amount that you decide to leave is again up to you, and it's just a risk thing. The cash that's in here is very safe. The cash and can potentially earn higher interest if you have a high interest savings account, and the cash over here is not as safe, but is where you're making all the spending from. So you need some money in that bank account too. Then let's quickly turn to the trust structure, and just so I can explain that in a bit of detail, then I'll come back to the questions. So on the right, we have at the bottom, we still have the dual company structure. But where trusts come in, which people may have heard of, is at the ownership level. So in addition to having your dual company structure or a single company structure, the way that the owners or the shareholders of the company hold their shares can be done in a couple of different ways. It can be a direct ownership, so the founders and the investors sort of themselves are the shareholders of the company, or instead of them personally owning their shares in their company, founders and investors can set up trust companies to hold their shares. And the advantage of holding your shares through a company is a fewfold. From a legal perspective, if you are a direct owner in your company as a founder, whilst you are protected from liability from employees and customers and clients, because in general they can only sue the operating company, they can't even pierce through to the holding company, and they certainly can't get back to the founders. If there is a dispute between founders or founders and investors up at this level, there's no companies in between them unless you have a trust company. And so an investor could personally sue a founder for some issue with the company and the way that it was run. And the founder's personal assets, their house, their home, their car, their electric car, whatever they own, could potentially be on the line to other investors. So unless there is an extra shield here, it can be a little risky for founders to personally hold their shares in their business. And so but for that reason and a couple of others, founders often will want to set up their own personal company, which acts as a shield from risk from other founders and potential investors. So you can see in this model, founder one is very protected. Employees can only come after the operating company. They certainly can't get through to the holding company, and no one can really get through the trust company. So they sort of have three shields from any kind of personal risk. So it can be quite effective. Now, why use a trust? There can be tax advantages. And again, whether the tax advantages are significant or not depends a little on your personal financial situation, and also on how your company ends up distributing its profits, or eventually, if you sell the company, how that process of sale works. But essentially, if your shares are held through a company or a trust company, there can be flexibility when the company generates income as to whether you are distributing that to yourself and paying whatever marginal tax rate you're on in the relevant year, or whether you're distributing it to sort of other places, companies that you may control, or other individuals. So it can have pretty significant tax advantages. And again, you can set it up later, but if you wait too long, moving from a single ownership to a trust essentially involves a founder selling their shares to their trust company, which is a share sale event. There's potentially capital gains tax. And so if the company has real value, not having a trust set up early on can become quite expensive. And it's actually quite a common problem we see for companies that have grown very quickly. The founders thought, oh, I'll deal with the trust thing later. And then when they tried to add in the trust, there was a big tax bill that they couldn't afford, and they ended up being stuck just being as owners of the company, which bit them sort of in the end. So again, Sprintlaw did start off as a single company structure, like many of you may be today, but pretty early on, we moved actually to this trust structure on the right. We set up the dual structure, and we moved the founder shareholdings into trust companies. And investors, it's up to them. Some of them may invest through a trust. Some of them may be funds, so they'll have a fund that invests. some of them may just invest as individuals. And that'll be their personal decision. And indeed, it is the founder's really personal decision as to whether they decide to set up a trust or not. It's not really a decision of the company. Um, and we generally suggest getting a little bit of accounting advice as to whether the trust makes sense for you. So a few questions I'll just quickly go through on this structuring. Kenneth asks, how about a trust setup in Oz and a holding company overseas and then an operating company back in Oz? Are there advantages or risks? The Probably can't go into that in great detail because I'm an Australian lawyer and don't have a great understanding of the Singaporean or Hong Kong tax system, but certainly conceptually that structure can work. Whether it makes any kind of sense from a tax perspective, you probably need to get specific tax advice on. The main reason people will set up holding companies for businesses in various countries, the decision is often governed by where the business is going to be operating and where the business is going to be raising funding. And for example, businesses that are heavily focused on the US will often, even if they are originally from Australia, either start with a US head company or flip into a US head company because it makes it a lot easier to operate in the US and raise funding there. Similarly, if you're operating in Southeast Asia, having a Singaporean head company might be more attractive for investors because it's easier to invest into for investors in that region than Australian head companies. Depending on the focus of your business, you may choose to set up there. But again, I think it's a decision around who may invest in your business, where do you operate, and then finally a personal taxation question. If I were to do it this way, yes, how would I hold my shares in the theoretical Singaporean company? Would I need an Australian trust, or maybe I need a Singaporean trust, etc. So there are tax and accounting advisors who do this stuff. Are the ones that often help you advise on different structures involving international, sort of international angle. And those are some of the considerations. But again, it's quite specific to your situation as to what the advantages or risk may be. So hopefully that answers that one. As Andrew said, if you're a sole trader with quite a scalable business in the digital space, what kind of revenue one must raise before turning the project into a dual company? Difficult question to answer, and again, not really a legal question, more of a business question. I think ultimately, if you've got a business that is doing well and you want to raise funding for the business, then from investors, then you're going to be pitching your business and saying, we're doing very well, and here is our potential market size, and here's where we think the business can be, and this is how we think, there may be a potential exit or the profits that we may make in the future. And so you'll be building your business's story, and revenue is only one piece of that. So I don't think it all turns on revenue. And ultimately, if you want somebody to invest in your business, at least using equity, which we'll be talking about in a moment, the difference between equity and other forms of fundraising, you kind of need to convert from a sole trader structure into a company structure. And as I said, if you do have big ambitions for the business, I would be looking at these dual or trust structures, but of course it could be a single company structure that you convert to. But as a sole trader, raising anything other than, debt funding and getting a loan, it's quite difficult because again, you can't really sell a stake in your sole trader business. The whole point of the company is that it's a separate thing that you can slice up like a cake and give pieces to. So that would at least be a threshold of you raising investment. If you're not raising investment, we still generally recommend that as your business becomes serious, you consider moving from a sole trader structure. Sole trader structures are really cheap and easy to set up, but for serious businesses, they're not great because you're just personally liable. So if something goes wrong in your business, the law doesn't see a difference between you, the sole trader, and you, the person who owns your house and all your other assets. So and also, there's taxation benefits for, again, once you hit certain revenue levels, there's company tax can be lower than personal income tax. So those are the considerations with moving from a sole trader. Tax implications with a dual company structure. I think I talked maybe after you asked that question a bit about the tax advantages or considerations, at least for the trust structure. The dual company structure as compared to the single, I mean, it's basically the same situation. You can file your tax return. And again, it's more of an accounting tax question than a legal one, but you can file your tax return as a consolidated group and kind of bring everything together, if that makes sense. And you're going to have to pay. I guess the main cost is you're going to have to pay two company registrations, two renewals, and do um, you know consider the taxation of two companies each year. So there's additional cost each year in managing this. But really, if we're talking about tax implications, it's more about this trust structure stuff that I mentioned earlier. Taylor's asked, what happens when you have a dual system with one company being a business entity, the other a not-for-profit doing research and AI work independently? Yeah, that's a pretty specific question. Uh, so yeah, in terms of when you say what happens, I suppose I'm not sure whether you're asking how should it be structured or how can you raise funding in that model if you have a not-for-profit. There's different ways to structure that arrangement. Sometimes people have a for-profit entity that might raise funding, and then a related but separate company that's a not-for-profit that may engage with that structure. Sometimes they're in the same group, although that might put restrictions on whether you can raise funds and what you can use them for if you have a not-for-profit in there, particularly if it's if it has DGR status. I think if you're doing a structure like that, where there's a not-for-profit mixed with a for-profit, you probably need to get some specific advice on how you should structure things, because it's a little complicated. And again, there's many different options, and there's both tax considerations and then sort of legal considerations with how you might use funds. Can you pay directors from the holding co and pay all other employees through the operating company? You can do that. Yeah, I'm not sure what the advantage would be. Maybe there is some tax advantage. I'd say, at least for our clients, that's not super common. Usually, just for simplicity, payrolls all run through one operating company. But you could theoretically do that. Yeah. Atul's asked, question. My wife's an employee of a company, but not a director of my company. I'm a sole director and shareholder. I now want to set up a holding company. Can my partner be a shareholder but still be employee of the operating company? That sounds like a fairly specific question rather than one that's broadly applicable. So again, maybe worth just personally reaching out to our team to answer that one, as I don't want to really give specific advice in a webinar call. Okay, there's a few more questions. I might come back to these so we can keep moving along with some of the other topics of conversation for today about capital raising, but I will come back to these questions at the end, and may end up staying a bit back after too if people want to stick around to hear the answers. So we've talked a bit about the company structure and setup. Let's now talk about capital raising. So you've got your company structure set up. Maybe you've done the dual company, the single company, or the trust structure. You've taken care of your legal hygiene, and you're now ready to think about going out to investors and raising funds for your business. Well, there's a few different types of ways that you can raise funding. First, we'll talk about equity or equity-related funding, where you're essentially selling an interest or a stake in your business to an investor. And there's three really common ways that we see this happen in Australia. We have the straight equity raise, which is what people would think from a common sense perspective raising capital means, where you are selling a percentage of your company to an investor. You give me, $100,000, and I'll give you 5% of the company. And that's kind of how a straight equity raise works. Fairly straightforward. The big decision, of course, in a straight equity is what is the percentage going to be for the dollars that are paid. But that you work that out with the investor, and then they own a stake in the business. Then we have the convertible note. The convertible note's a little different. You might think of it as like a early bird ticket to a future equity raise. So the company might decide, hey, I don't want to work out what percentage of the company I'm giving away yet, because I don't know whether 100K, if you give me 100K, I should give you 5%, 10%, 15%, 20%. I don't know what we're really worth right now because we're so early in what we're doing. So instead of giving a percentage of the company away right now, I'm going to take your $100,000 and I won't tell you what percentage you're getting yet, but what I'll tell you is you'll get a discount on the price per share that other investors pay in future. So if right now, if you give me 100K and then next year I do my straight equity raise, investors at that point paying 100K, they're only going to get 5%, but you'll get, uh, you know, um, a 20% discount. So you might get 7% instead of 5% for your 100K. So it's uh, less certain for the investor. They don't know what percentage they're getting, but they know they're getting a better deal than future investors by some discount rate. Now, if the company never does a straight equity raise, the convertible note can be also, and there's different ways to structure it, can also be treated as a loan. And so it says, okay, if you never do that equity raise, you've just got to pay me back that 100K that I gave you on the convertible note plus some interest. And there might be an interest rate in the convertible note. There's a few other terms. Again, we'll go through convertible notes in more detail in a moment, but that's kind of the difference. The straight equity is X dollars now for Y%. Convertible note is X dollars now for a discount on, Y% that other people pay later. The safe note is pretty much the same as a convertible note. It just doesn't have the loan aspect, the interest rate. It's super, super simple. The safe note was invented by Y Combinator, who are like a famous accelerator in the US, really to find a super fast, simple, easy to understand way for early stage companies to raise funding and to also get around some debt securities laws in the US that made convertible notes more complicated than they would otherwise be. And then they became really popular. And in the last sort of 5 years in Australia, they've become one of the main ways that people raise funding. Interestingly, in Australia, we didn't really have that same uh, debt law problem, and convertible notes were kind of fine here, but safe notes just became really popular, and so people are using them a lot to raise funding. So the safe note again is pretty much the same as a convertible note. Invest X dollars and get a percentage discount on the company's next capital raise, which is pretty much the same as a convertible notes, the early bird discount. They just don't have the loan and interest concept. So in a sense, it's on its face, and then there's different forms of safe note. On its face, it's better for the company rather than the investor because the investor in the convertible note at least has a loan as a fallback with some interest. Whereas in the safe note, at least in the most basic version of the safe note, if the equity round never happens, they kind of have early bird tickets to a show that never happens. The safe note holders may not actually get their stake in the business. Of course, there are workarounds for that in terms of having things like maturity dates and auto conversions and so on. And again, we'll dive into that in a moment. But in general, the safe note is very similar to the convertible note, except it doesn't really have the loan and the interest. So hopefully that's starting to make sense. We've got our straight equity and we've got our early bird discounts, the convertible note and the safe note. Now, there's other funding types, of course. There's other ways to get money for your business. You don't have to raise through selling a stake in your business. You can get government grants. There's all kinds of grants from, export grants for those expanding overseas or R&D grants for those doing scientific or technical innovation. There's commercialization grants, there's state-based grants. So a lot of startup companies rely on grants for funding, which often don't involve you giving away any part of the business. You just getting it from the government or a body. There's loans. You can get personal loans. You can get loans from friends and family. There are now is an emerging industry in Australia of venture debt organizations who will give loans to early stage companies as well. Usually loans work how you think they work. You're going to get an amount of cash for your business, but you're going to have to repay it over a period of time. And that can be difficult for startup companies to do because you may not know when you're going to be making enough revenue to repay the loan. So it often suits slightly more established businesses better. But equally, if you get a long enough loan term and you're confident you can pay it back, it can be a really great way to raise funding without having to sell a part of the business, usually with a debt. There's crowdfunding. People probably know what that is. You can go do a Kickstarter campaign, depending on what your business is, and get a bunch of donations for potentially prizes. And then there's equity crowdfunding, which is a new form of crowdfunding, which allows you to conduct straight equity raises online from a big pool of potential investors. And there's a few platforms like virtual and on market, um, who facilitate those. So for those interested in equity crowdfunding, I won't cover it in great detail, but you can check out those websites, virtual and on market in Australia, and they have really great guidance on how their process works. But high level, it's similar to the straight equity raise. There's just some other considerations. So that's a bit of an overview of the landscape um, of fundraising. Now, we'll just talk in a little bit more detail about the equity raise. So if you decide that you're going to do an equity raise, you're going to sell a percentage of your company in exchange for an investment. How does that actually work? What's the process? So usually what's going to happen for at least a startup fundraise is the business is going to prepare some kind of business plan or pitch deck. They're going to prepare a bit of a forecast and build the business story as to why this is a really great investment and why an investor may want to put funds in this business for a potential return in the future. So that's again not really a legal piece. That's a piece for you to sort of work on as a business. We're growing really fast. We think the market for this is of X size. We think this business is worth this today, but will be worth this other thing in the future, 5 times what it's currently worth. And if you invest $100,000 today, we think we might get acquired for 5 times what we're worth, and you'll make a $400,000 return on your investment at that time. That's a very basic version of what story and pitch you might be preparing. So once you've prepared your business case or story for why your business is investable, what you're usually going to do is design a term sheet. It doesn't always work this way, depending on who you work with. Sometimes the investor will design the term sheet, but the term sheet you can imagine is a couple of page document, fairly straightforward, that explains the key details of what you're looking for. We, the company, are looking to raise $500,000, $300,000, $100,000, $1 million, whatever it is, $5 million, this amount of money. And we are going to be giving away this amount total of the business. So let's say you're raising $100,000 and you're going to give away 10% of the business. That implies that the valuation of the company is $1 million. So, it's 10% of the company at a valuation of $1 million. We're going to be giving away 10% of the company for $100,000 to investors. Investors will, have these rights in the business. They must invest a minimum check size of $50,000 if they want to join. Here is the timeline, so on and so forth. So you must keep all information that we share confidential. So a term sheet is usually a fairly short document, and you have a version of it which will basically be the document under which you start to get commitments from investors. So an investor may sign a term sheet that says, I agree to put in principle $100,000 or $50,000 in your business for X% of the business, and I will work with you to agree all of the documents to finalize this, if that makes sense. So what you're often doing in the early stages of an equity raise, there's a ton of legal documents we have down at the bottom of this screen that need to be prepared to formalize the investment. But you don't want to be negotiating all of those with all of your potential investors if you're going to have 2, 5, 7 investors. So you'll often start with this really simple term sheet. It may not be legally binding. It usually isn't legally binding, but it's kind of like a handshake agreement written down on paper that this person intends to invest in your business and the high level terms. So often when you're raising funding, you're going to be going out trying to get term sheets signed. As I said, you may be the one that designs the term sheet. Sometimes if you're pitching to venture capital firms, you'll just pitch the business and they'll give you their term sheet and they'll say, look, these are the terms on which we're willing to invest. But that term sheet is kind of that first stage of the equity fundraising process, at least, where you're getting commitments of how much people are going to invest and on what terms in your business. Once you've signed term sheets, let's say you're raising $100,000, maybe $500,000, let's just say, and you get 5 people that agree to put in $100,000. They all sign a term sheet saying, I'm happy to put in $100,000. Now we get to the more in-depth legal part, and this is where lawyers start to get involved. Now that you have these term sheets signed, you obviously want to get that money transferred into your business's bank account, and you also want to confirm how things are going to work, because these people are about to become part owners of the business. So there's a few different legal documents that you're going to be putting together in an equity raise. The first is a shareholders agreement, which sets out what rights the founders have as compared to the investors. I alluded to this earlier, but it says things like certain decisions of the company the founders can just make without consulting investors, but certain decisions will require 100% approval, or certain decisions will require 70% approval, or 60% approval, or whatever it is. Um, it might say things like, uh, the company will hold meetings at X frequency. If the investors have questions about what the company's doing, here's what the company has to provide, but here's what it doesn't have to provide, and so on and so forth. So it's quite an important document that sets out how the company is going to be run once these people come in and what rights the investors will have. And you want to get that really clear, so it's very clear what you do and don't have to do for the investors who are investing the funds. You'll also have a constitution. It's a fairly generic document that basically talks a bit about how the company as a whole is run in terms of having directors meetings and things like that. And then you have the subscription agreement. And the subscription agreement, so where the shareholders agreement talks about how the company will be run, the subscription agreement is kind of like the investment agreement. It's the document that says uh, the investor promises to put in X dollars and is going to receive Y shares, the same day that they invest the X dollars. And the investor's putting in this money on the basis that, the company's provided accurate information, it has not been misleading, and has given materials that, fairly represent the business, for example. So that's kind of the key part. There's the subscription agreement, which is the document under which the investor puts money into the business. And then there are these shareholders agreement and the constitution, which are kind of the governing documents once they have invested, how things are run afterwards, if that makes sense. So it takes a bit of time to negotiate these things. People often go back and forth on what will be in the shareholders agreement, what the subscription agreement will say, and so on, which is why the process is usually split into getting these term sheets signed and then having the ongoing documents or more complex documents negotiated later. In addition to these, sometimes there are other documents that happen in an equity raise. Again, mostly hygiene stuff. Sometimes investors require, founders who haven't yet properly set themselves up with employment agreements, put those in place, who haven't signed IP assignment deeds confirming that, the founders won't take the IP and go and start another business, and other sorts of things. So there can be a few other documents that get signed around an equity raise, but generally it's mostly that subscription agreement and the shareholders agreement are the big two that get signed after the term sheet. So that's the overview of the equity raise. Diane has asked, do you need to get them to sign an NDA? An NDA is an optional thing that you can do. It's reasonably common, but early in the process, often when you're sharing all of your forecasts and documents and pitch decks with investors, you might be nervous that they're going to share that with other people and steal all of your ideas and information. And so you can request that before you share confidential information about your business with investors, that they sign an NDA, which is a simple document that says you promise not to take any of the confidential information about my business that I'm sharing with you and send it to other people or use it for other purposes. Investors are usually happy to sign those. I will say usually when you're fundraising, you've got like your pitch deck, which is like the high level summary of your business. And then you've got like a stack of other documents like your financial forecast, your numbers, details on your strategy, and a bit more in-depth stuff. Usually it's the second packet of information that you would get the NDA signed for. If you're getting NDA signed really early before you even share your pitch deck with people, it can be off-putting for investors because, they don't even know what they're signing an NDA for, and it's a bit of a friction point for them to even just learn a bit about your business. So more as a practical point, I'd say it's not that common to sign NDAs before sharing a pitch deck. And if you've got a pitch deck that has really confidential stuff in it, maybe strip that out and have a version of it that you wouldn't be mind getting shared around, and do that without an NDA, and then only use the NDA if someone's like quite interested. That would be probably my general recommendation, unless what you're doing is so confidential that even the deck itself, it'll be risky. Then you might want to do the NDA up front. Jed has asked, does a friends and family round involve these documents, term sheets, or does it tend to be less formal? Yeah, so In a moment, I'm going to talk about safes and convertible notes, but I would say it's actually more common to use safe notes and convertible notes with friends and family because they are less formal, as we'll talk about in a moment. But if you are doing an equity raise with friends and family, yes, they are often less formal because you may not need to run a whole process with term sheets and all this kind of stuff. Still, I would say usually you would have some kind of term sheet. Maybe it's even just a paragraph in an email confirming high level what they're going to be signing up to. And then your friends and family will say, yes, I'm in. And then you'll go to the stage of sending them the shareholders agreement and the subscription agreement. So you still probably will end up doing it in something like two stages, but it might not be that you have a formal document called term sheet. You get all the six people to sign up at the same time, and then it may be a little less formal in general, but still you really do have those same stages. But again, the safe note and convertible note we'll talk about in a moment can be a lot simpler. Um, I got a question. We've raised funds before and are looking to raise again, starting with our current shareholders. We didn't have the subscription agreement. Is that a legal concern? Um, you probably Yeah, I'm not sure how you agreed to get the funds transferred to the business, whether that was just done as a handshake agreement. But um, look, in general, a shareholders agreement is the more important ongoing document, and the subscription agreement is more just a record of the transaction. It often serves to protect the investor more than the company because the investor will be relying on promises that they've made, the company's made, which is these company warranties that are included in the subscription agreement. It varies from situation to situation, but it can often be worse for the investor to not have one. Um, in general, yeah, I can't really say if it's a legal concern for you without looking at the specific documents. But it's usually not a massive concern if you have a friendly relationship with the shareholders, and any messiness that might have flowed from that could potentially be cleaned up in a secondary funding in the funding round documents that you do now. So I just get some advice on that topic to confirm. Okay, Adam's asked about raising from the public. We'll come back to that because we have some notes on that. So just on the equity raise, I just wanted to quickly touch on this. When you're doing the equity raise, you've got the shareholders agreement, the subscription agreement, and they contain some of these things. They'll talk about whether the investor has a right to be on the board, so any rights to control the company, whether the founders have vesting criteria. So sometimes you often see investors saying, okay, I'm going to give you $1 million to the business for let's say 10% of the company. But if one of the founders leaves within the next 2 years, I don't want them owning still, 40% of the company. Um, uh, I'm putting in $1 million. I need these person to guarantee they're going to stay and work really hard for the next few years. And if they leave within 2 years, they're going to forfeit some of their equity stake. So they often have these vesting clauses that will lock in the founders. That's worth being aware of. There's restraints in there. So it'll often say, hey, I'll give you this $1 million, but you must promise not to start a competitive business or be doing some side things that compete with what we're trying to do here. They might want ongoing access to information. You must give me monthly or quarterly updates. They might want promises about the company that, everything you share with them is true. Sometimes you see these clauses called liquidity preferences, which, are a little more technical, but basically say, if I put in $1 million as an investor into your business, um, and I only get 10% of your company, um, and then your company ends up selling for not that much, $5 million, rather than me getting um, 10% of 5 million when I put in at 10% of 10 million, I'll just get my $1 million back. So they kind of have a flaw. They say, all right, I'm happy to only own 10% of your company if it does well. But if your company doesn't do that well, and I would end up making a loss, instead of that, I have a liquidity preference. So when your company doesn't do that well, I get my $1 million back. So it can be a protection for them. And some aggressive investors say, I want a two times liquidity preference, which means I want at least $2 million, even if the company doesn't do that well. So again, you can see why that's good for investors, but can be less good for other shareholders. And then anti-dilution as well. The investor might say, I'm happy to give you $1 million for 10% of your company. But if you raise funding next year and you're giving away 10% for less than $1 million, I want some anti-dilution rights, which means I want to get a bit more equity for free if you decide the company in future is worth less than it is today because you told me it was going to go up and it's gone down. And again, there's often these protections for investors that can end up diluting founders or giving them unideal outcomes when the company exits. So you got to pay careful attention to those if you're doing an equity raise. And I'd always get those carefully checked by lawyers before signing anything with a liquidity preference or an anti-dilution. So let's now talk about safe notes and convertible notes. These are an alternative to the equity documents. Rather than running the full round where you have the term sheet, the shareholders agreement, the convertible notes, the shareholders agreement, subscription agreement. Instead, what's becoming more popular is to use these documents called safe notes and convertible notes, which are, as I mentioned earlier, your early bird tickets to the equity show, where what you're saying to the investor is, hey, put $100,000 in my business. I'm not going to tell you what you're going to get, but you'll get a better rate than future equity investors by some discount. And as I said, safes and convertibles are pretty similar, except the convertible notes typically have interest on them if the company never eventuates into an equity raise. They can be repaid with interest. Usually in the most basic version of a safe note, all you have is the discount and the amount being invested. There are a few other terms, though, that have been added over time to the safe notes to provide a few more protections for investors in case the equity round doesn't happen or the equity round, suddenly the company grows 100 times or something, and the investors feel that they didn't get as much of a return as they should have for investing early. So you have this concept of a valuation cap, which basically says, okay, I will get a 10% discount, let's say, on your next fundraise, but if your next fundraise is at a really high valuation, then my discount will be not on the valuation of your company at the next round, but on this capped valuation. So if your company, I'm going to invest $100,000 in your company via a safe note with a 10% discount and a $10 million valuation cap. That means if your company is suddenly worth $100 million, my safe note will convert into equity as if your company was only worth $10 million. Because I got in before you blew up, if that makes sense. So it's a cap on the conversion price, and it can be a really great term for an investor to know basically the minimum equity that they're going to get. Because if you just give them a discount, they have no idea what the discount's going to be on because you haven't told them what the future price will be. But if you give them a cap, you say you're going to get a discount on the valuation agreed by future investors. But if that valuation is really, really high, we will act as if it's just this cap. So so they at least know their kind of minimum equity that they're going to get. So very common in safe notes is to just have the discount and the valuation cap. 10, 20% discount, 5 million valuation cap, for example, is a common seed stage safe note or convertible note. And then, as I said, there's a definition in there of when does this safe note turn into equity. They usually say at your next qualifying fundraise when you raise equity. And so usually if someone's raising a safe note, they're going to be planning to do an equity raise of a larger amount in the next couple of years, which is why they're doing the safe or the convertible note. And finally, increasingly, we're seeing this maturity date appear in the safe notes. A lot of people are raising safe notes, claiming they're going to raise an equity round in the next 2 years, but then they never actually do. The safe investors are not feeling very safe because they have a discount. They've got an early bird ticket to a show that never happened. So oftentimes you'll say, hey, if the company doesn't do anything in the next 2 years, then the safe is going to automatically convert into equity on this date at this valuation cap, for example. And so again, the safe investor now, it's a bit more of a secure document for them. They're giving you money. They don't have their equity today, but they know they're going to get a discount if you do raise equity. And if you don't raise equity, they know that after a year or 2 years, it'll automatically turn into equity. And that I'd say is one of the more common structures for safe notes, at least in 2025. Last year, we saw that happening a lot. So hopefully that makes sense. And usually in terms of all of these rights, like shareholding rights, subscription rights, and so on, the safe holders, you don't negotiate any of that when you do a safe note. You literally just sign the safe document. But the document says the safe holders will have the same rights as the people that come in the equity round. the same shareholding and appointment rights, if that makes sense. So that's kind of how it usually fits together. So we've covered the equity raise. We've talked a little bit about the safe and the convertible raise. One thing to mention, which I think we had a question about from Adam, in Australia, if you're raising funds for a startup company, uh, because you're not a publicly listed company, you can't kind of go out and like post all over the internet and do digital marketing for your fundraise. It's not legal. Um, in general, the general law in Australia is anyone that wants to raise funding from the public needs to either A, do it through equity crowdfunding, which is its own process, or B, prepare something called a prospectus, which is a really long document that has a whole bunch of risks about the business disclosed to the public, and it's very complicated to prepare. Nearly no startups want to prepare a prospectus, so they rely on a particular section of the Corporations Act that says it's kind of the small companies exception that says, look, we'll allow small companies to raise funds without a prospectus. They can just raise it privately from in their own way, provided that it meets one of these 7 criteria. And there's 7 different criteria. There's the friends and family rule, and there's like a definition of friends and family that you can raise funding from without a prospectus. There's the 2012 2 rule. If you raise from less than 20 people, an amount of under $2 million in 12 months. There's a sophisticated investor rule. If the investors are sophisticated, which means that they've got a certain amount of net assets or income, if any one of those exceptions applies, you can raise funding without needing to do the prospectus. But none of them really allow you to go out and be marketing it broadly, which is why you don't see like startups out there shouting to the public that they're raising funding. They have to do it privately, and they have to fall into one of these exceptions, or they would be breaching the law. So the answer, Adam, is no, you don't really need a prospectus as long as you fall under one of these exceptions and you sort of raise generally privately, unless you do something like equity crowdfunding. Now, for those other types of funding I mentioned, grants, debt, crowdfunding, equity crowdfunding, they have their own legal docs. And again, I won't go through any of them in great detail, but just to be aware, grants usually have a grant agreement, which is conditions attached to grant funding. Debts have a loan agreement. Crowdfunding platforms have terms and conditions, and equity crowdfunding, they have usually a shareholders type agreement that all of the public agree to when they get shares in your company, which we call a CSF constitution. So there will be different legal docs if you go down one of these different funding pathways. So we're just over 2, and that was the legal content that I wanted to cover for today, which hopefully has given you all a nice introduction to equity raising, safe and convertible raising, and also some of these other forms of funding. I am going to stick around and go through all of these questions, and if anyone else has other questions, do feel free to drop them in. For those dropping off, I hope you enjoyed the webinar, and we do these every month, so please come along to the next one. And of course, don't be afraid to reach out to our team if you do need help with anything. So let me just run through these questions. I'm going to go from the top. Question here, in the trust structure, do you mean that there should be a trust and then have a trustee company, and then in the trustee company, the shareholding would be between the founders of the trustee company, or set up a company and in that company have the trustee company as a shareholder? So I'll just go back to the slide to be quite clear about what I meant. So in the trust structure, each founder has their own trust. So for example, if I, Alex Solo, was a founder, I would have the Alex Solo Trust. And if John Smith was the other founder, they would have the John Smith Trust Company. So it's a personal trust company. Both founders don't usually have a stake in the same company. It's a personal trust company, and that trust company would own the stake in the holding company, if that makes sense. So a personal trust company to hold your shares in the holding company, and then everyone would hold the shares together in the holding company. So hopefully that answers that question. Success, I'm about to get an ABN. Do I need to set up a single company immediately with an accountant, or wait until I start making profit? Yeah, I guess it depends on your business goals and whether you're raising funding. And I touched on this a little earlier, but it's perfectly fine to set up as a sole trader when you're just getting started with your business. As soon as your business becomes serious, or if you're taking risks on, or you're going to employ people, you're going to raise funding or do anything a little more serious, a company structure becomes much more advantageous, and it can be more advantageous from day one. It just costs more money. So you can wait if that's what makes sense for your current situation. But if you are doing risky things, or you're starting to make more income, or you're planning to raise, or you're planning to employ people, those are the times that you really want to start about getting that company structure set up. Um, Adam's asked, can you raise with a self-managed super fund, and how many members can there be? A lot of everyday people, but are willing to invest for their super. Um, yeah, you can have SMSF as investors in your company, and a lot of angel investors in startup companies do so through the SMSF. Um, there are sometimes specific um, tax requirements for really on the investor side for them to make an investment. So they might ask you questions about like what's the company worth, or what do you estimate that it's worth? And they might need some extra information from you in order to make sure that SMSF is compliant with its investment. But certainly, it's possible for SMSFs to invest in startups, and again, we see that quite common and quite commonly. In terms of how many members can there be, in general, for private companies, there's a limit of 50 shareholders, which is uh, a kind of cap. And if you have more than 50 shareholders, you have to actually convert to be a public company. Now, there's some exceptions or workarounds. There's an exception if you're an equity crowdfunded company, you can have more than 50 shareholders. And also sometimes companies that want to raise a small amount from a lot of people and are looking like they're going to go over that 50 cap will often set up like a group of investors in a what's called a bear trust or a syndicate, so that they can group a bunch of shareholders into one kind of shareholding slot. But yeah, in general, it's a 50% cap. Brian said, can a holding company get all the license and operation company work under holding company licenses? Um, it depends what licenses you're talking about, because each industry has its own licenses, and some industries there aren't really any licenses required. Um, so yeah, probably a bit too general a question to answer, but usually it's actually the other way around. Your operating company, the one that's actually doing business and getting licensed to operate in whatever field it may need to be licensed in, would need to be the one that's licensed. So, for example, Sprintlaw is licensed essentially as a law firm to provide legal practice. That has to be our operating company that's licensed. It can't be our holding company. So yeah, that's usually how it works. But the holding company can still hold assets, but usually the person actually doing the work needs the license. But again, it depends on which license we're talking about. Adam said, "What if it is 2 mil but more people? Um, you then can't rely on that exception, but you may be able to rely on other exceptions, like the sophisticated investor exception or the friends and family exception." And yeah, there's a few others that I don't have listed here as well. Um, I'd say usually we find a way for reasonable fundraisers to work, unless people are raising from like 100 people, at which point it becomes quite difficult, and you might want to consider doing an equity crowd fundraise. What are investors getting into crowdfunding if it is not an equity crowdfunding? Oftentimes, it will be for like a product business that might be selling its product in advance of it launching. So, if you are, I don't know, a new clothing brand, you might sell your clothes for funding, which you haven't yet made, but you're going to use all of the pre-orders to make the clothes, if that makes sense. So it's often called rewards-based crowdfunding, and you can think of it as like a um, pre-ordering based funding, just like get your customers to pay you in advance so that you can actually create the business. Um, so yeah, again, Kickstarter is probably one of the most well-known crowdfunding platforms, so you can check it out for more details on that. Awesome. Hopefully that answered, I think I answered Adam's question earlier. Hopefully that answers everyone's questions. But again, if you have more specific questions to your business, do feel free to reach out to our team. And I hope everyone found this useful. Thank you all so much. I'll see you later.